The brain, a complex mystery organ that influences everything a person does, thinks, or feels. Life after a brain injury can feel just as mysterious and complex, trying to navigate services, experiencing potential isolation, different functioning, and much more. The rehabilitation process can impact the person as well as their supporters. It's often filled with ups, downs, and everything in between, all while the brain is relearning and making new connections within. Join us as the Brain Injury Association of North Carolina sits down with brain injury advocates to discuss a variety of topics surrounding life after brain injury. The more we understand the different aspects of services and effects of brain injury, the better we can help make connections within our community for individuals living with a brain injury. This is Making Connections. Today, we're going to talk about disability law. Hello, thank you everyone for joining us today. We are here to talk a little bit about disability and how that works in the legal sense. And we're here with Gowan Moise with DeMayo Law, and I'm going to kind of turn it over to him to tell us a little bit about yourself and how you got involved with working with individuals living with brain injury.
Of course. Thank you, Lauren. I've been an attorney since 1994. I started my practice conducting civil litigation primarily, both in the areas of personal injury and workers' compensation. One of the very first complex workers' compensation cases I was involved with involved a gentleman who had sustained a brain injury as a result of a construction site injury in 1995. He fell from some scaffolding and sustained a head injury in that fall. So I was introduced to clients with brain injuries fairly early in my practice, and learned about the complexity of litigating those cases pretty early. I had a number of clients in that practice, both in personal injury and workers' compensation. A client of mine was involved in a rollover car accident, a young man, a teenager, who sustained a very severe brain injury also in 1995. In a few years after that, work that I did in civil litigation with the number of injured individuals that I've been working with, I moved over to private practice as general counsel with the social service agency in Atlanta. Stayed with them for about 7 years, and we represented individuals who were filing disability applications as well as Medicaid applications. A lot of those folks that we represented were children. Some of them had congenital brain injuries. And so I had a chance to represent kids, which was very meaningful to me, not only in Social Security claims, but in Medicaid claims. In 2005, I left that practice, that agency rather, and formed my own practice with a partner. And we focused entirely on Social Security disability claims, where I've really focused my practice for the last 16 years now. I worked in the Atlanta area for a number of years, became managing attorney for a firm that had a regional practice that was based out of West Virginia. And we practiced in Ohio, Virginia, North Carolina, and also West Virginia, and a little bit in Kentucky as well. And that's how I came to North Carolina, how I came to Charlotte. I moved from that practice to DeMayo Law Offices in 2020, and I've been with the firm for about a year. And I head up the Social Security department for this practice. So more than 25 years now dealing with not only injured individuals, but folks who have civil claims in workers' compensation, but in the area of personal injury, but also and more than anything else, really in the Social Security arena. But all along the timeline, I've represented individuals who are not only injured but have had brain injuries from various sources, either through personal injury, work-related injuries, or congenital nature. Represented older individuals, younger individuals, everywhere in between. So, and a variety of levels of severity. But that's I have a fairly varied background. So.
Yeah, it definitely sounds like it. I'd be curious if you saw any sort of trends for kind of the causes of brain injury. Do they typically are they all over the place all the time, or is it there are certain times of the year where you see specific causes? Or I'd be curious if you saw any trends like that anecdotally.
Yeah, it seems to be in the areas of, well, in personal injury, especially if you're dealing with motor vehicle accidents. The winter time seems to be a more likely time for accidents, probably when the weather is bad. But as far as any other type of work related injuries, there didn't ever seem to be a trend with that. Work related injuries are a year round issue. But with motor vehicle accidents, the wintertime is worse than any other time of year. When it came to representing children, when I was with the agency in the late 90s and early 2000s, the obviously very young children dealing with the congenital injuries, and the limitations that came from that, when you would develop them and you would see them very early on in their life. Usually when we were getting kids approved, it was in the first 18 months of life. You were able to really establish what you needed to establish pretty early on. We didn't see a lot of children who were 8 or 10 or 12 years old if they had long-standing issues of any kind. Usually they were getting approved pretty quickly and getting the assistance they needed pretty quickly. Didn't see a lot of children that were 8, 10, 12 years old with injuries. I never really represented a lot of kids of that age who sustained injuries at that point. A lot of teenagers, usually from some type of catastrophic injury, more than anything else. But those seem to be the trends, if there were any, really.
Excellent, very interesting. So you mentioned that you've worked in the field of kind of disability for a long time, and I know that throughout the entire disability world, service arena, et cetera, these terms SSI and SSDI get kind of thrown around, tossed around, sometimes really quickly in a conversation. Can you talk a little bit more about what that really means? What do those letters stand for?
Of course, yeah, and it's an important distinction. SSI stands for Supplemental Security Income. SSI is the federal income that was created to help aged, blind, or disabled people who have little or no income. It's an entirely need-based program. An individual need not ever worked at any point in their life to potentially qualify for SSI, as long as you meet the financial criteria for SSI. They look at household income, they look at assets and resources. Now the threshold is very, very low. Essentially, you would need to be below the federal poverty guidelines, generally speaking, to qualify for SSI. So if an individual is not worked at all, but they're married and their spouse works and has a certain amount of income that's above that threshold, they might not qualify for SSI. So it is somewhat difficult to qualify from a financial standpoint. You have to be very impoverished in order to qualify for the financial criteria for SSI. SSDI stands for Social Security Disability Insurance. That's the other program. By contrast, that's entirely based on work credits. And when you pay into Social Security, you generate work credits. When you get a paycheck and you see FICA come out of your payroll check, that's when you make that payment into the Social Security program. And again, the threshold is not particularly high with this. You can make a couple $1,000s a quarter and qualify to earn a credit for that particular quarter. And what Social Security is going to look for as far as your work credits is generally speaking, if you've worked 5 out of the last 10 years, you're going to qualify, have enough work credits to qualify. Now, younger people, if you think, well, I'm 22 or 23 years old, I haven't really had that much of a time in my life to work, and yet I'm injured and I'm disabled, they do somewhat prorate those credits to allow you to have adequate work credits under the program. So if you've worked a couple of years and you're still early in your working life and you sustain an injury and become disabled, you may still qualify for the credits. But those are specific procedural details. But generally speaking, SSI is the needs-based program. SSDI is the work credit-based program. Doesn't worry about assets or resources. You can have a lot of money in the bank. You can have a lot of assets, a lot of resources. Your spouse can work. You can have household income that's really, really high. If you have enough work credits, you'll qualify as long as you're disabled for SSDI.
Okay, that makes sense. And so how does that either correlate or often coincide with like Medicaid supported programs or things like that? What makes it different, or maybe what makes it similar in your experience?
Sure. Medicaid is also a need-based type of program. If you qualify for SSI, you qualify for Medicaid. It's an automatic eligibility for Medicaid. It is possible to have Medicaid eligibility and not be collecting SSI. Pregnant women, children qualify if you meet financial criteria for SSI. Medicare, by contrast, comes along with SSDI. There is a waiting period before an individual becomes eligible for Medicare. Medicare is the federal health program. Medicaid is federally funded, but managed by each individual state. And there are different criteria depending on what state you live in for qualifications for SSI. For Medicare, those qualifications are going to be the same across the board.
Okay, yeah, that kind of clears all that. I know that it's so hard to figure out kind of where everything trickles down and what kind of benefits are out there for everyone, just because, brain injury and any sort of disability is so different from person to person. And so where does a disability lawyer or someone in your role, what do you guys do? Where does that kind of fit into everything?
Sure. The Social Security process, excuse me, is an administrative process. It's not a formal judicial process at the outset. And by that I mean, when you apply for benefits, you go through an application process, and you have a lot of hoops that you have to jump through, a lot of forms you have to fill out, and so there are a lot of administrative requirements. Not only just the rules that you have to satisfy in order to qualify, but a lot of red tape, I guess, if you want to call it that. As a disability attorney, one of the things that I do is try to make that process easier. When we have individuals who are disabled for whatever reason they might be disabled, but particularly for someone who has a brain injury, obviously the organizational demands of going through all the forms, going through all of knowing what documents you've got to produce and fill out and complete and submit to the different agencies, not only Social Security, but the state agencies that do the medical workup for the programs. You want to make sure that you get those things right. One of the things that I can do is I can make that easier. We're used to filling out those forms. We're used to completing and doing a lot of the hoop jumping, as I call it, to get through to the other side and get those things complete. We do make things easier, but when we get far along in the process, and there are multiple levels that one has to deal with the Social Security Administration, when you get to the hearing level, which is the third stage of a claim, if an individual is denied at the initial level, they might be denied at the reconsideration level, which is the first level of appeal. They might have to request a hearing and go before an administrative law judge. And that's really the point at which an attorney who specializes in the area of disability can be most helpful. It becomes a little bit more of a judicial process at that point. It's still an administrative process. It's non-adversarial, meaning that Social Security is not at that level going to bring in an attorney to cross-examine witnesses to try to prove that an individual is not disabled. That's not the format of these type of proceedings. The judges will take evidence, will take testimony, a disability attorney can develop that testimony at a hearing that's going to be most favorable for a disabled individual. Try to point out to the judge what rules are most appropriate to apply, what medical evidence is most important to consider in those cases. And knowing the rules and knowing the process and procedure is where you can really give yourself an advantage by having an attorney at your side.
Absolutely. Just kind of going through you're talking about all the different processes. I'm like, oh gosh, yeah, I wouldn't want to go through that alone. Like, absolutely not. People with brain injury are already dealing with so much. And so, having someone to be able to kind of show you what to do next can be really helpful. You mentioned that the kind of executive functions are what they're called, organizing your thoughts and doing all the paperwork. How would someone with a brain injury be eligible for disability benefits? What are kind of some specific things that might make them unable to do regular, life things and maybe make them seek out disability compensation?
Sure. When I evaluate clients who have brain injuries, I look at two elements of their case and the way that I would want to present something. One, I want to look at their executive function and their cognitive limitations. Social Security is rather structured in the way that they review cases when they evaluate someone's cognitive ability and their executive function. They look at whether a person has limitations in their ability to understand information, remember information, and apply information. They look at the way that somebody might interact with other people, thinking of it in terms of a work setting, how they might be able to interact with supervisors or coworkers or the general public in jobs that might have those requirements, and how their thought processes might impact them there. How they might be able to concentrate on completing tasks, focusing on details, or how they might be able to maintain pace in the way that they conduct activities. Can they work at a reasonable speed, or is some of the problem that they might have with processing information going to impact their ability to work at speed? Or looking at even completing basic tasks. Social Security breaks down jobs. When they look at a person's ability to do certain types of jobs, they look at three kinds of jobs: skilled jobs, semi-skilled jobs, and unskilled jobs. And oftentimes, because of cognitive limitations or executive function limitations, a person might not be able to do even unskilled work, the demands of unskilled work. And if that's the case, from a mental standpoint, the person might not be able to work competitively. And so that would be one area that I would try to evaluate a claim. The other area, of course, is from a physical standpoint. Does a person have limitations in their motor function? Do they have difficulty, for instance, going from a sitting position to a standing position? Do they have balance issues? Do they have problems using their arms or their hands? Would they be able to, do they have compromised gross function, or do they have problems with dexterity and fine motor coordination? Those type of limitations would certainly impact the different kinds of jobs that a person would be able to perform. When we think, for example, of a person who does a sit-down job, not necessarily working at a computer, but say they work in a job where they assemble small parts, or they might do something with their hands. Most sit-down jobs require the ability to use both hands and have that manual dexterity. If a person with a brain injury doesn't have that fine motor coordination, you can eliminate most sedentary jobs just by not having fine motor coordination. So we look at it from a vocational standpoint. How is it going to impact not only the mental limitations, but the physical limitations as well, or both? Oftentimes you're dealing with both.
Yeah, there definitely can be a lot that can impact, whether or not someone can perform daily activities, find jobs, etc. And so what have you seen as either the biggest mistake that you see clients make, or maybe on the flip side, something a little bit more positive? What's the best thing that people can do when they're looking to receive disability benefits?
Sure. I think that one of the first things they can do to help themselves as early on as possible is make sure that you have a conversation with your treating provider. Talk to your doctor, and let them know, I'm looking to file a disability claim, and I might need your assistance in putting together an assessment of my functional capacity. Social Security um, doesn't consider the opinions of doctors that are conclusory. And one of the biggest mistakes that people will make is when they come to me, and they're with good intentions. They come to me and they'll say, "My doctor is going to help me with this," and they've written me a letter, and the letter says that I'm disabled. Know that 100% of the time, Social Security will ignore that statement from a treating physician. And people think, well, wait a minute, my doctor says I'm disabled. Why is Social Security not paying attention to that? And it's because it's conclusory. Social Security won't pay any attention to that opinion. They'll pay attention to a doctor's opinion about what a person's limitations are. For instance, if the doctor writes something that says, because of my patient's injury, they can only stand 15 minutes out of every hour and would need to sit down because they have balance problems. And it would be risky for them to stand more than 15 minutes out of an hour. Social Security will take that statement from a doctor and they'll process it and they'll determine what kind of limitations a person has with regard to their ability to do certain types of jobs. But if a doctor just comes out and says, my patient has this type of injury and is therefore disabled, Social Security won't pay any attention to that. So when you talk to your doctor and you solicit their assistance in filing a disability claim, you want to make sure that they are understanding the best kind of information they can give you is talking about what your limitations are. My patient has difficulty concentrating on anything more than simple 1 and 2 step tasks, for instance. Might have problems with concentration in that they wouldn't be able to maintain concentration for more than an hour at a time without taking a 15 or a 30-minute break and disengaging from whatever activity they're doing. Those type of quantified type of limitations are really the most helpful things that we can get from a treating source. So getting that cooperation from a doctor early on and getting them to say, sure, I can put together a set of limitations for you, that's going to be really, really helpful. That's what I look for when I'm communicating with a client's providers. I tell those doctors, this is what I need you to do. I don't need you to tell me that they're disabled. I'm going to prove that they're disabled by using the information that you give me here. So this is what the information is that I want from you. I hope that makes sense. Everybody does come to me with good intentions and saying, I've got my doctor's cooperation. And I usually have to circle back to them and say, I appreciate that, but this is really the information that I need from you. And then we turn it into a really helpful format. So.
Yeah, that I love that. That's really something that everyone can do that's very tangible, making sure that it's those specific terms, not necessarily the large underarching, disabled, but what really does that mean specifically for the individual and how does that impact their daily life? So that I hope everyone who needed to hear that heard that part. And so you talked about, getting a note to the doctor, talking to what does the process for applying for disability benefits look like? You touched on it a little bit in terms of it's a long process and there's a lot that goes into it. Can you give us kind of an overview of what that looks like?
Of course. It is a long process. I will say to Social Security's credit, it's better than it used to be. Having been in this, doing Social Security work for as long as I have, for having done this for as long as I have, rather, I've seen periods of time where the process of application, from initial application up through the hearing level, would take sometimes 2.5, even 3 years to get to that point. It's not that bad anymore. It's still longer than it should be. Right now, we're seeing, at least in North Carolina, we're seeing anywhere from a year to a year and a half to get through the hearing level process. Beyond the hearing level, and I'll talk about that in a minute when I talk about the different levels, um, may take a little bit longer than a year to a year and a half. Sometimes that depends on the complexity of the case and the volume of medical evidence that you're dealing with. But starting at the initial level, when you file an application with Social Security, you're applying for benefits at what we call the initial level. If you can expect anywhere from 2 to maybe 5 months at the outside to receive a decision from Social Security on that on a medical basis. And I say on a medical basis because if you apply and you don't meet the technical criteria, going back to what I was talking about earlier with SSI, for instance, if you have too much household income or if your assets or resources are too high, you'll get a denial pretty quickly from Social Security about that, usually within a week or 10 days. And those hard and fast rules, you can appeal them, but there's not much reason to do so unless your financial circumstances change. And it would change the technical outcome of that case. What I'm talking about in this area of focus really has to do with the medical review, not really the technical aspects of the claim. So from a medical basis, you can, at the initial level, probably 2 to 5 months. Sometimes it might take toward 5 months, depending on Social Security's interest in seeing how a person is progressing. For instance, if you're undergoing treatment, and Social Security might look at it and say, well, we're not exactly sure what the long-term limitations are going to be, so we're going to let this play out a little bit longer and see what happens. By example, if an individual sustained a head injury, a brain injury in a motor vehicle accident, and they might wait a couple of months to do a neuropsychological evaluation to see if there's a period of recovery. They might wait to see what the results of that evaluation would be, to see what the longer term effects would be before they would make that initial decision. I've seen that before, and that's not out of the ordinary. Once a person is, let's assume that they're denied at the initial level, you can file what's called a request for reconsideration. The case would go back to the state agency that does those medical reviews for Social Security at the initial level. They do those medical reviews at the initial and the reconsideration level. You would have a different adjudicator, a different medical review officer, look at the updated medical evidence and the older medical evidence and make a new decision on that. At the reconsideration level, you can usually expect 3 to 4 months before a determination comes down. It is a clean review. Again, there are new people involved with that. Unfortunately, we don't usually see the results at the reconsideration level that we would like. A very small percentage of those cases that are denied at the initial level are overturned and found favorable at the reconsideration level. It does happen, it's just not very often. After the reconsideration stage, if you're denied at that on that second occasion, you request a hearing before an administrative law judge. And the wait time to get your case in front of a judge kind of depends on your jurisdiction. It depends on what hearing office is managing your case. Different hearing offices have different timelines for cases to be heard, largely depending on how many cases are in that jurisdiction at any given time. With COVID, hearings now are being conducted by telephone and by video. There aren't any in-person hearings, and there haven't been any since March of 2020. So to the extent that Social Security is able to hear cases by telephone, they can move cases around to different jurisdictions. By example, I had a case week before last that was heard by a judge in Memphis, Tennessee, because one of the judges who had a rather large caseload, they shifted some cases to a different judge in a different jurisdiction. So it didn't have to be delayed any longer than it already had been. So we are seeing some flexibility on the part of Social Security by having judges in different locations hear cases where that hasn't necessarily been the case in the past. So it's a little bit more efficient to that extent. The hearing level, probably 6 months, I would say, is about as fast as you can expect to be heard once that hearing request is submitted. Right now, I want to say, at least in the Charlotte hearing office, we're seeing about 9 months from request until that hearing happens. Some cases are taking a little bit longer than that, but not much. So we're seeing about a year and a half overall, maybe 20 months from the initial application to the hearing level. If a person's denied at the hearing level, there is the ability to file an appeal, which is still within the administrative forum that Social Security has. It goes to the Appeals Council, which is located in Falls Church, Virginia. There is no hearing at that level. It is a request for review. Usually we're dealing with specific analytical errors that a judge might make in issuing that decision. You try to pick out mistakes that the judge may have made, bring it to the attention of the Appeals Council with the hope that you can get it overturned and sent back down for another hearing or possibly for a favorable decision. If a person is denied at the Appeals Council, usually they don't deny cases at the Appeals Council, although they can. They might just choose not to overturn a case, saying we didn't find any mistakes that would change the outcome in the case and would therefore do nothing in the case. At that point, you do have the ability to file suit against Social Security. And then it becomes a judicial process where you're trying to get a federal magistrate to overturn the administrative law judge's decision, send the case back down to the administrative level, and have the case heard again. When we get into that level of review, we're talking about a longer timeline. The federal district litigation can sometimes take up to a year. I've seen it last a year and a half or even 2 years. So you're talking about a very long process at that point. The administrative process, ideally, if we can get things resolved at the administrative level, we certainly want to do it then for the benefit of everybody, because the timelines are becoming so long after that.
We'll be right back.
I was 15 when I was in an accident.
I fell at work. I was a victim of abuse.
Over 200,000 North Carolinians are living with a brain injury. For those living with a brain injury or caring for those who do, the Brain Injury Association of North Carolina is here to offer help, hope, and a voice. We connect you with available providers, support groups, and get the answers you need on your journey after a brain injury. Visit BIANC.net now for more information on our education, support, prevention, and advocacy programs.
Yeah, you definitely weren't kidding about the administrative process of how, the different steps and all that takes. I hear a lot from people, that apply for SSI, apply for SSDI, and they get the first letter says, denied. How common would you say that is for people to kind of get that denial level letter? If it's not based on the logistics, like you mentioned, but the medical qualifications.
Right. If it's not a technical denial, if you don't lack work credits or you're over income, if we're not dealing with those issues, if it's purely a medical issue, statistically over the last several years, dealing between 50 and 55% of those applicants are denied at the initial level. That to me is an extraordinarily high number. And when we look at the numbers at the hearing level of the number of cases that are ultimately approved at the hearing level, you can really see what kind of problem we're having at the initial level. There are a lot of people that are denied at the initial level, ultimately approved, but about a little bit over 50% of people who apply at the initial level are denied. When a case goes to the reconsideration level, I mentioned just a few minutes ago that we see a very small number of people who are approved at the reconsideration level. It's actually less than 10%. So when we think of it in terms of a little bit more than 50% of the people who are denied at the initial level have their cases reviewed. Only 10% of those 50% who are denied who go on appeal are approved. So it's a very small percentage at reconsideration. But then when we get to the hearing level, a little bit over 50% of those people who go to the hearing level are approved. And so that's where having a disability attorney can really be helpful for you. So make sure that your case is presented in the best way possible, to make sure that all of the evidence is considered, the appropriate evidence is considered, that the rules are going to be applied accurately to the details of your case, that nothing gets missed. And I would say that most people are represented by counsel at the hearing level, not necessarily at the initial or reconsideration stages. I do see a lot of clients, folks who become my clients, who come to me. I just got denied at the reconsideration level. I appealed it myself. I appealed my initial denial and I just got denied at a reconsideration. Or they come to me after they do that initial application and they say, look, I filed the application and I got turned down. I need your help. I want you to file this appeal for me. So I do pick up, I do gain clients at the initial denial. I gain them when they get denied at reconsideration. Folks who have requested that hearing, they come to me. I'm starting to get a little bit nervous because they're about to schedule a hearing for me, and I'm not sure I can represent myself at that hearing. That's really the point where you're going to do well to have an attorney by your side. But I think it's a testament to being represented at the hearing level, having those cases presented in the best way possible. But it's good news. I think that people do get approved at those rates at the hearing level. I just wish it was sooner. I wish it was at the initial and reconsideration stage. There are a lot of people who need help out there and need it sooner rather than later. And getting your case organized and presented in that fashion is the best way possible.
Yeah, I certainly agree. So it sounds like, really be persistent. If you get that first denial, don't give
Absolutely.
up. And it sounds like going through the appeals process is better than, starting a whole new claim or trying to go, start a new one or anything like that. Would you say that that's accurate?
That's definitely the case. One of the things that I'm glad you mentioned that. One of the things that I do see from time to time with folks who come to me who become clients, they will tell me I've applied 5 or 6 times. And once I get into their file and I see what they've done, instead of filing an appeal, they just go back and they file a new application. And filing a new application is not the same thing as filing an appeal. If you go back and you say, well, I'm just going to go at it again. If you go through the application process, Social Security will look at that and they'll say, well, you're just reapplying. We're not going to consider this to be an appeal. If you don't do it timely, Social Security, generally speaking, on appeals, you're going to have a 60-day timeline to file an appeal. There are some exceptions to that, but overall, if you have an initial denial, you're going to have 60 days to file an appeal. If you get denied at reconsideration, you're going to have 60 days to file that request for hearing. Sometimes people will wait beyond that. They'll 75, 80, 85 days. They'll go in and just file a new application where if they had a good reason for missing that appeal deadline, they could go back and say, hey, look, I was in the hospital for a month and I didn't get this denial. Can you accept my appeal late? Social Security sometimes will say, we can do that. We understand you were hospitalized. And so we'll take that appeal late and they'll process it as an appeal. It makes a huge difference when it comes to protecting your right to recover retroactive benefits rather than filing a new application. Sometimes we can go back and we can fix that depending on the dates and the timeline. But just understand that filing a new application is not the same thing as filing an appeal. You're always going to be better off if you can appeal that decision and preserve it. Preserves benefits, also may preserve eligibility for Medicare, may allow you to backdate. As I mentioned quite a while ago, there is a waiting period to become eligible for Medicare. And if you can establish a start date of your disability farther back and your paid benefits retroactively, that Medicare eligibility date will be sooner rather than later down the road because of your receipt of benefits. But appeals almost always going to be better than filing a new application.
Excellent. Yeah, that's a really good distinction. You mentioned a little bit about the doctor and having that person kind of behind you, writing specific functional limitations that might help you through the process. What other type of documentation is needed or helpful? Sometimes we see, people that have had injuries a long time ago, or maybe they didn't keep all of their medical documentation. What should people be, making sure that they hold on to if they get any sort of scans or testing done?
Right. That's a great question. There are a lot of different things that are important. I can't give you an exhaustive list, of course, but some of the things that I commonly see in representing folks with brain injuries. therapy records, rehabilitation records, seeing what kind of progress a person might make as they go through the rehabilitation process, neuropsychological evaluations, which I think I mentioned earlier, to see what kind of specific limitations a person might be expected to have going forward. Those type of reports are going to be helpful. School records are oftentimes very, very helpful, especially if a person has sustained an injury as an adult. If there was any type of testing, grades from high school or college, aptitude testing, so you can show before and after. Those type of evaluations are usually quite helpful. If you're a child, those school records are going to be extremely helpful. Any school records that you may have prior to an injury, and certainly any kind of adjustments, IEPs, things of that nature, school programs that the child is in, are going to be very, very helpful. But overall, the medical providers, the source statements are, in my opinion, are going to be the most helpful when it comes to establishing what a person's limitations happen to be. Whether it's, we talked about the fine motor skills and gross motor skills, and so those treating sources that are going to be able to address what kind of physical limitations a person has, or from a psychological perspective, if you have a psychologist or a psychiatrist or a neuropsychological report to talk about any kind of cognitive limitations that there may be, those are going to be extremely helpful. And obviously any correspondence from the treating source that specifically attends to those type of limitations, that's going to be the most helpful thing we can obtain.
Yeah, it sounds like keep it all in a binder and
Right.
bring it all in, even if you don't think you need it now, keep it all. And so can you give an example about how you've worked with someone with a brain injury before? You mentioned a few cases before at the start of your talk today, but without any sort of personal information given. Can you kind of talk about what that looked like specifically for an individual as an example?
Sure. I had a client a number of years ago who sustained a head injury, and he was aphasic. He had speech issues. He was able to speak, but had very limited and very hesitant speech, to the extent that he was very hard to understand even when he could speak. And a lot of that, even though it was documented, it was not documented. The extent of it was not documented as well as I would have liked it to have been. And so we ended up going to a hearing in his case, and I wanted the judge to be able to hear him, understanding that if my client were in a work environment, it would be difficult or almost impossible to understand what he had to say, for him to relate things verbally to coworkers or supervisors, or obviously the general public, would have been difficult or impossible. But getting that point across to the judge, perhaps reading the documents, reading some of the therapy. I mean, his therapy records, as I recall, were actually really good because they were so encouraging to him. You're progressing, you're coming along, you're doing well. Well, relative to everything else, he was doing well, but overall, he really struggled. And so we got him in front of the judge and let the judge understand. And it didn't take very long for the judge to understand in a work setting that it would not have been possible for him to work competitively. So in that particular case, it was important to have an actual presentation. In another case, I had an individual who, the teenager that I represented a very long time ago in that rollover accident, his case was important. His school records, he was a very good student in high school. He was 17 when he was injured. And he had some cognitive testing after that. He was unable to finish school because of some of the concentration impairment that he had. He had terrible headaches, and problems with his concentration after that. And we were able to demonstrate that some of the things that he did academically prior to his injury required a lot of concentration, and that he was such a good student that the change was very, very notable. And it let us really clarify for the administration what kind of limitations he would have going forward, even in doing simple tasks. The ability to concentrate on simple tasks was a real chore for him. We were able to get him assistance pretty early on. We were able to get him approved within about a year and a half. As I recall, he was just about 19 when he got approved. Those are a couple of examples of working with clients of mine. Some of the more difficult cases involve younger children, because you don't necessarily have a benchmark to go from. And so in those circumstances, you really rely on the treating source to project what kind of limitations a child might have. Social Security has what are called listed impairments, where if an individual's conditions are significant enough that they meet specific criteria, that it creates a presumption of disability. With younger children, you hope to have enough evidence to be able to prove that. Otherwise, it tends to be rather difficult because you don't have that benchmark to go off of, and you have to go back to the treating source and pull information and have them project information. But the older a person is, usually the more data you have, and you can put that information together in a cohesive presentation and show before and after. You can show limitations based on current testing. Those are going to be most helpful.
Yeah, as I'm listening to you speak, it sounds like your role is to make something that is anything but black and white brain injury. There's so much range, there's so many differences and things like that. And your job is to put it in black and white, literally ink, kind of putting all of the objective pieces together. And I think that makes it really difficult for some things that you mentioned, like things that are invisible. You mentioned someone having headaches, difficulty with concentration. What does that look like for those individuals that maybe they look fine on the outside? Will they have a lot more difficulty kind of going through the justice system? Have you seen, or the kind of administrative process? Have you seen stigma related to brain injury in kind of your work, or what do you have? What has your experience been?
Yeah, there's a lot to unwrap there, and it's yes, and in a lot of ways I have over the years, and it's one of the more frustrating aspects of representing individuals with brain injuries. Unfortunately, there are a lot of judges that if you can't see it, it doesn't exist. Not only with brain injuries, but other conditions like, for instance, fibromyalgia is a case that we see where a person has body pain. Pain is subjective. There's no objective way that you can measure pain. Pain is different for everybody. I might have a high pain tolerance as opposed to you. If you have a low pain tolerance, the same type of thing might bother me a lot more than it bothers you, and vice versa. When we have a person with a brain injury who has headaches, for instance, it's very hard to quantify that. It's very hard to get across to someone who can't see that type of problem that you're having and having them believe that. One of the things that I have clients do who have headaches, for instance, or who have sleep problems because of pain, sometimes that's a common issue with folks with brain injuries, is I have them keep a diary. If they have a headache on this particular day, if they take medication, if they had to lie down in a dark room for X number of hours, to document those things. That's evidence. We can submit that as documentary evidence at a hearing. And if I have 18 months or 2 years of diary entries where a person has headaches 5 days a week consistently for a period of 2 years, I can turn that into a statement for the judge to say, if I have an individual who lacks the ability to go to work 5 days out of 7 over the course of a week, what is that going to do to their ability to work competitively? If their headaches are so debilitating that it makes them absent, it takes them off task. From a vocational standpoint, it's going to eliminate that person's ability to work competitively. But it goes back to the larger problem. That's a problem that you can't see, that you can't quantify. And so there is unfortunately a stigma, not only for elements that we might see of people who have brain injuries, but also when we look at some of the things that we were talking about from a cognitive standpoint, the problems that people might have in engaging with other people if they have difficulty managing emotions. That's not something you can see until it manifests itself when a person's in a work environment, for instance. But if they go to a psychologist or a psychiatrist or a counselor, and they talk about those limitations that they have, I'm having a hard time managing my emotions with my friends and my family. And we document that, and we document that, and we document that. That's not something you can see, but if it's documented because you're talking to somebody about it, we can use that as evidence to say, you can't see this, but it's happening because this client of mine is reporting this to a medical source. That's another example of something that you don't see, but we can ultimately prove by using the best possible evidence of documenting it. The administration is better than it used to be. I will say there are a lot of judges who recognize that unseen things are actually there, and will listen to individuals when they testify about pain or concentration problems, and will take it at face value. Unfortunately, there are still judges that are stuck in a rather archaic time, and if you can't see it, it doesn't exist. We do the very best we can to document those cases in the best way that we know, through treating sources, through diaries, as I mentioned, as one example of ways to document those files. And again, it's all about getting as much evidence through that variety of means to do that, present the case in the best way possible.
Absolutely. I think that awareness about brain injury is definitely starting to get in the forefront of people's minds, but there's still a long way to go, and particularly, in the judicial system as well. As we kind of wrap up here, I thank you so much for the information and your time. And I think we've gone over a lot of different topics. So I hope that everyone took away something from this talk, but I'll kind of leave you with the kind of final either takeaways, or if you want to talk a little bit about how they can get in contact with you, I'll leave you with the final thoughts.
Of course, thank you. The best advice that I can give to anybody who is trying to get assistance through Social Security because of a brain injury, don't give up. Do not give up. Social Security is going to make it difficult for you. They make it difficult for everybody in the application process. There are a lot of hoops to jump through. There's a lot of red tape to try to cut through. And you have to be persistent. You have to be relentless in the way you pursue your claim. Getting an attorney, whether it's me or somebody else, I would certainly recommend that you do that. It will make things easier as far as putting aside a lot of the stress and what may feel like a really overwhelming process. And it is an overwhelming process. It is designed to be that way. It is a government agency with a lot of forms and a lot of hoops to jump through. But be persistent in that regard. You can get in touch with me through the main office line. I'm located in the Charlotte office, and our main number is 704-333-1000. I will give you my direct telephone number as well if you want to give me a call directly. I do return my calls. I'll do my very best to return calls within 24 hours if I'm caught up in court, or otherwise, leave me a message and I will call you back. My direct line is 704-944-1257. That's 704-944-1257. And my name again is Gowan. Don't call me Mr. Moise. I'll turn around and look for my father over my shoulder. Please ask for me by my first name. I'm happy to talk to you. If you have any questions about the disability process, I'm happy to answer them, give you some guidance and some direction about filing a claim, or evidence in your claim, and what you might need to get prepared to file a claim, or if I can help you in any way, I'm happy to talk to you about your case.
Thank you so much. I think the transparency and education and awareness is key for us, very complicated system, for a very complicated condition, living with brain injury. And so I really appreciate your knowledge, and I hope that we can work together again someday to, just help more people either figure out the process or other types of aspects related to brain injury. So thanks so much.
Absolutely. Thank you. It's what it's all about. I've tried to guide my career. I take a lot of happiness and pride and joy in helping people and getting good results and getting them help. People don't go to Social Security and go through this process unless they're in need of help. And so I take a great deal of satisfaction in helping folks and getting them benefits and getting them help. So if I can help you, let me know. I'm happy to. I'll talk disability cases and the disability process all day long. It's what I do, and it's what I love to do.
Excellent. Thank you so much. I hope you have a wonderful
you.
day.
All right, Lauren. Thank you. Take care.
Bye.
Bye-bye.